Good morning. I'm Karen Milton. I'm sitting here in New York, in Manhattan, and together with my fellow judges, Mark Simons and Charlie Hinderlad, we're here to listen to your prepared statement and then have some follow-up questions. I'm currently the Chief of Staff in the Office of the MTA Inspector General. That's the New York State authority that oversees the New York City subways and buses and the commuter rails in the greater New York metropolitan area. Prior to that, I was the circuit executive. That's the chief operating officer of the Second Circuit, which are the 13 federal courts in the states of New York, Vermont, and Connecticut. Now I'm going to ask my fellow judges to introduce them. Charlie.
Charlie Hinderlad, Director of Government Affairs for St. Louis Realtors in St. Louis, Missouri. I'm a former political science professor, and many years ago, I was a student in the We the People program on the other side of the proverbial table, I guess, as it is right now.
Good morning, Mark Simons, and I'm in Reno, Nevada. I've practiced law for lots of years, it doesn't matter. And my pitch to you is you can get paid doing exactly what you're doing in the future. So keep that in mind. Your team, one starting today, you got a day under your belt. Welcome to the Nationals, day 2. Excited to talk with you. Good luck. Thank you.
All right, thanks, Mark and Charlie. So if you're ready, we're ready, and I'd like to read the question.
We want them to introduce themselves.
Oh, that's right. Sorry, guys. Do you want to introduce yourselves and your teacher? Sorry, thanks.
Hi, I'm Alexis Smith.
I'm CC Eubanks.
And I'm Kenneth O.
And our coach is Kevin Rippey.
Well, welcome to all of you. And I think now we're ready. Let me read the question. So we're in Unit 1 and we're doing question 2 today, right? We're all in agreement? Okay. So here we go. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? And under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? You can begin.
Habeas corpus is a writ used in every type of detention situation by the government. It decides whether the detainee's detention is lawful and ensures that the person in custody is brought before the court and informed of the charges they are being held on. While Parliament passed the Habeas Corpus Act in 1679, it first originated in the 39th clause of the Magna Carta, famously known for protecting and highlighting rule of law, especially in regards to those in power. This clause supported the idea of due process in a time when kings typically had the tyrannical power of imprisoning whoever they wished without any form of a judiciary system being involved. The writ of habeas corpus is essential to limited government to a great extent because it ensures that the citizens' rights to due process are protected, thus limiting government power in criminal cases. For example, in the Supreme Court case Buck versus David, Buck, a man who was sentenced to death for murdering his wife, issued a writ of habeas corpus because he had an ineffective assistance of counsel in his trial, which violates the constitutional right to a fair trial in Amendment 6. Buck's lawyer was found to be inadequately representing him due to racial prejudices. The writ of habeas corpus acts as a protector of due process laws in Amendments 6 through 8, rights that have carried importance for centuries. Even Hamilton's Federalist 84 includes a prohibition of the suspension of habeas corpus as a provision of protecting individual liberties, limiting the power of the government in a time when tyranny unfairly imprisoned many. The writ of habeas corpus acts as a check on the judicial branch to maintain our constitutional government.
The writ of habeas corpus is prevalent in any circumstance relating to due process, such as seen in the 5th and 14th Amendments. Amendment 8 outlines that excessive bail is unlawful, thus the writ of habeas corpus can be used to appeal bail amounts if the citizen feels the amount is unlawful. Furthermore, the Constitution includes protections such as the suspension clause in Article 1, Section 9, which protects this privilege from being infringed upon by the government, unless in situations that this privilege threatens public safety. For example, Abraham Lincoln suspended the writ when the Civil War broke out. However, this action was challenged by Chief Justice Roger B. Taney, ex parte Merriam, in 1861, revealing Taney's idea that the power of suspension of habeas corpus lies with the Congress and not the President. Even in World War II, Franklin Delano Roosevelt suspended the writ when a failed attempt by Nazis at sabotage led to the apprehension of 8 German soldiers. Many thought the suspension was an abuse of power and violated the captives' 5th and 6th Amendment rights. However, because they were committing unlawful acts of war, they were therefore unlawful enemy combatants. More recently, the case of Boumediene versus Bush, the Supreme Court clarified that habeas corpus extends to those who are non-citizens of the US, in a circumstance concerning apprehended terrorists being detained in Guantanamo Bay. This is another example of the writ playing its role in government, checking the executive branch and protecting individual liberties, as well as advancing with the world in situations such as those that are present that the present day threats provide.
I believe that habeas corpus can place an overly large burden on the government, but it is something that the government has to find a balance and spot for, as it is an essential right of the people. Habeas corpus has been suspended in times of great civil unrest, such as in 2006 under President Bush under the Military Commissions Act, and recently with the BLM protest. The idea of the government is that the large amounts of arrest place too much strain upon our judicial system that, without the suspension of habeas corpus, we would have essentially stopped to a standstill. These can be valid reasons to temporarily suspend habeas corpus, but the issue is, the rights of the people should be protected. Our founding fathers included habeas corpus of other similar rights, such as the rights to a speedy trial of jury, as they all promote due process. The balance between state rights and individual rights should be respected, as our system of government functions off this system of trust, this social contract. In fact, it can be argued that without habeas corpus, 9 of our 10 rights from the Bill of Rights are violated. Considering all of this, the government should always have the rights of the individual in mind first, and only suspend habeas corpus as a last resort. Although the burden can be large, it certainly isn't unreasonable given the importance of habeas corpus.
All right, thank you for your prepared statement. Let's start off with this. How does habeas corpus fit with the guarantee of due process in the 5th and 14th Amendment? Talk about that nexus.
I think that habeas corpus fits with the idea of due process by ensuring that those apprehending those that need to be apprehended, so the police force, whoever is doing that job, ensures that they are not playing as the judge, jury, and executioner, so that they are ensuring this right of due process that we are given in our country.
I think a good example of this is the case that I mentioned, the Buck versus Davis case. In that one, he was inadequately represented by his lawyer because they had racial prejudices towards him. But so this upholds the 5th and 14th Amendments because he appealed his prosecution or his trial to get it re-looked at, since he wasn't getting that fair treatment in his trial.
And one thing that I want to emphasize is that habeas corpus kind of allows the individual themselves to like speak up within amidst like the big like government power, right? So whenever they're under trial, they can object to something that they feel is wrong, such as an unfair trial, unfair like type of detention, right? So they can appeal that and have some sort of say.
Okay, I'm going to follow up. I'm giving you a 2-part question. One to follow up on Charlie's question is, what part of the 5th or the 6th or the 14th Amendment empowers somebody to have representation by counsel? And secondarily, what other provisions in the Constitution trigger to protect people against arbitrary acts by the government?
Well, when we talk about the process of due process and the amendments that come with it, we have to emphasize the fact that like people have the right to the fair trial, especially like with a jury. And so when we talk about habeas corpus, it definitely is an integral part of this, as having a fair trial, and the guarantee of a fair trial helps people, I guess, have the representation within the government and within the law that because they're on the other side of the law when they are in their trial. So.
And concerning the context of the habeas corpus and how important it was when building the Constitution, the colonists had just come from a tyrannical king that was imprisoning people without fair trial. And that was one of the things, such as representation, taxation, and due process were really the big ideas that the Constitution was focusing on in terms of how the government actually controls people.
I think it's important to kind of see how all the things tie together. So, habeas corpus is used to ensure that the amendments are being upheld. So in the Fifth and Sixth Amendments that you mentioned, it talks about that they should have their trial in front of a jury, that they don't have to have witness against themselves, which that connects to other cases like the, I think it was Gideon versus Wainwright when he wasn't given a judge or a lawyer, I'm sorry. But habeas corpus itself upholds due process, which is established in the Constitution by those amendments.
So are the state governments impacted by habeas corpus, or how does habeas corpus have any bearing on the state governments, the state criminal justice system?
I think habeas corpus, as we said in our prepared remarks, it has an impact on any situation involving the judicial system and bringing someone to the court of law for their trial. And that's the point of habeas corpus. So if it was only on a national level, it would kind of defeat the purpose of having this writ so that people do have a fair trial, because somebody could be detained unfairly by the state government without having this trial if it wasn't affected by the state government.
And one thing I want to emphasize is that, like, under the Constitution, we have like the Supremacy Clause, which basically says that like the national government and like the laws that pertain to them kind of also like go with the state government unless like otherwise righted, right? So when we talk about like the habeas corpus and how due process is like written inside the Constitution and all that, we have to like think about rule of law and how like not even the state government or the national government are above the law, and we have to realize that like habeas corpus should apply to and does apply to everything, as no one is above the Constitution, as it is the framework for our entire system of government.
Do you think habeas corpus lives up to its nickname of the Great Writ? Do you think it's that important in our constitutional system?
I think it's incredibly important to our Constitution. If we had no abilities to, I'm trying to think of the word, to kind of check the judiciary branch, then they could, that's pretty much what our entire Constitution was built on, is that they didn't want a tyrannical government that could do whatever they want. So checks and balances are incredibly important, and things such as the writ of habeas corpus are a way that we as individuals can make sure that our government systems aren't taking advantage of us.
When we going off what Alexis said, our country was based off like the system of like checks and balances. And I feel like it's not just checks and balances between like the three branches of government, also checks and balances between like the constituency, us, and the government itself, and in this case, like the judiciary branch when we come to trial, right? So because they have the abilities that bring us under the law and because of stuff, we should also have the abilities to like, check them and raise issue if we find something to be wrong and have an outside force like assist us if needed.
And that's why there was so much, that's one of the reasons why there was so much outcry with the murder of George Floyd by a government system, by the police forces, because he was not brought in front of a jury for his crimes. Many believe that, the cop that murdered him was serving out his sentence without bringing him forward in front of the jury, like the habeas corpus promises.
Okay, I'm going to hit you with, tell me what are the situations where suspension in your mind is appropriate, the suspending of the habeas corpus?
I think in terms of suspension, of course, the suspension clause lists out that when public safety is threatened through the writ of habeas corpus, a suspension is allowed. And I think there's also times when habeas corpus is just simply unable to, be upheld, whether in terms of like the massiveness of the group committing the crime.
And this kind of goes off the issue between like the common good and individual rights. And when the common good should be prioritized, and the common good should sometimes be prioritized over individual rights when it is when, as he said, it like threatens the good of the nation. So that it's only in those instances where habeas corpus should be suspended.
Okay, time. All right, good job. Yay. Now it's time for feedback from the judges.
All right. Well, thank you all. I really enjoyed our conversation. I wish we had more time. A couple of little things. One, since this, I think, is your first time out today, Kenneth and Cece, when you guys are talking, there's a little bit of background noise. There's something maybe in your connection. You may want to play with that a little bit before the next group goes. We could still understand everything you said. It was just slightly distracting. Also, for your prepared statement, we're going to hear it once. Feel free to slow down. I'd use a Micro Machines reference, but I'm pretty sure you're not old enough to understand what the heck I'm talking about. So there were some points in your prepared statement where you were just motoring. And we only get one crack at this, so make sure I know you've put a lot of time into that prepared statement. Make sure we get to hear it all. You guys, I think, really understood and were able to place this in the right theoretical context. I like how you ended on this notion of common good versus individual rights, how you guys really were able to focus on the Great Writ as a check on government power and how that's really essential to procedural due process in limited government. And I think you guys did a nice job. Thank you.
Okay, take a deep breath. First team out, you got it done. Now, I'm going to give you some feedback. I really appreciated that you were able to give me the Gideon versus Ringwright, because when you, in your prepared statement, you talk about the ineffective assistance of counsel, but there's actually nothing in the Constitution that says that. It says a person has a right, or the accused has a right to a fair trial, but it doesn't say that means this. And so that's how the Constitution has been expanded. And that's why I threw it out to you and say, hey, wait, where does it say that the government has to provide a defense for you, which is even a greater expansion on the writ to protect against the tyrannical forces of the government. So you hit that, and I wanted the suspension. You clearly have the framework and the understanding of what this is all about. Thought you did a great job. I thought you, for being the first team out, you did a great job on day 2. So thank you.
Yeah, I would. Totally agree with my fellow judges. Very nice job. Habeas corpus is not an easy discussion. You guys had a great understanding of the historic underpinnings and its importance to the founders and how they worked it in. And I thought you had some nice case law to support how the writ has been, how the guarantees of the writ have been expanded even beyond what was envisioned in the Constitution. So great job. And best of luck in the rest of the competition. Thanks so much. It was a great conversation.
All right. Woohoo, good job.